I am very familiar with the business realities. What I'm thinking of is what some of you may say, well, you know, there's nothing I can do with this contract. I got to just sign it. Number one, as we discussed this morning, that people will say that to you all the time, and I can tell you with confidence because I often represent the GCs and the owners or whatever. It's not true. It depends on how strong your bid is. It depends on how strong your qualifications are compared to the other people bidding on this project. It depends on how much competition you have. It depends on the GC's personality, the owner's personality. It depends on a lot of things. But nobody, even Clark Construction, will change their contract. There's nobody. A lot of people will tell you we don't agree to change anything. That's not 100% true with anybody. I do understand that a lot of the times a customer is going to insist on their form. Now, we are in the second half of Chapter 2 now, and we're really going to go right in order on it. Deadline for acceptance. Battle of the Forms, order acknowledgement. Starting on page 13, 14. Guarantees. Yes. All right, page 27, I'm sorry. Review and contracts received. And we're really going to go just in the order that that text is. All right. You're looking for the 5 greatest hits. You cannot rewrite the whole contract. You cannot mark it all up from one end to the other. If we would have preferred to just draft the contract to start with, we can agree on that, and you're not going to be able to do that. So what you're looking for is the 5 greatest hits, and that's what I want to help you to understand and help you to look out for. There are certain things that debtors are more likely to agree to because you have the power of reason behind you. It's reasonable. Or to put the same thing another way, their provision is obviously unfair and onerous, which that's actually true of some contractual provisions. You need to recognize those. You need to find things you can change with just a couple of words, if you can. And you need to find things that are really going to pull money out of your pocket. Some stuff will not. An indemnity clause is a good example. I get more calls about indemnity clauses. They go on for a full page, single-spaced. They're frightening. We can agree they're absolutely, if you read one of those before you went to bed, you'd never get any sleep. But it doesn't matter. That's what insurance is for. Those are insurance provisions. What you care about, what matters, is whether the casualty insurance policy you have covers this risk. The most important thing you can do is send a copy of this contract to your insurance agent and ask them to please confirm that the policies you're paying him premiums for cover this risk. It is possible that an indemnity clause is out of bounds, you have to pay the costs whether they cause the damage themselves or not. I mean, that can be a problem, but the typical indemnity clause, even though it reads scary and it goes on for a full page, is not really a problem. And I like to cite that just as an example of a clause you're probably not going to touch unless it is completely out of bounds and patently obvious. Okay. So the first thing you're going to do, we decided, one of the handouts I gave you is the proposal. Appendix 5, proposal for labor and materials. Appendix 6 was a supplier proposal. This is a labor and materials proposal. The first thing, what we're talking about this morning, is that every bid you ever submit, you're going to put it on this form. To put the same thing another way, I am always surprised and I'm always disappointed with clients sending bids in, and they're really, really smart about describing the scope of work they're going to perform, and they're really good about putting their exclusions in there. Here's all the things that are excluded from the scope of work. And they send it off, and that's the end of the story. There was a flip side of that sheet of paper. You had a whole blank sheet of paper. You could have put some basic legal terms, and you didn't. You had an opportunity to get some leverage, an opportunity to control your costs and your risk. You made no use of that opportunity. That is a mistake. Every bid you send, make sure you got one 8.5 by 11 sheet of terms with all of the things we've talked about all morning. Now, you're going to do that for a couple different reasons. One is your debtor may just sign the doggone thing and send it back to you. And now you have made use of your opportunity to control the contract documents. And again, if the debtor signs it and sent it back to you and you had no terms on there, that was a missed opportunity. What's more likely to happen?
If you send them that and then they just automatically send you back a purchase order.
Yes. Okay, well, that's what we're going to talk about from now till lunch. But sometimes they'll send you a purchase order, and then you have to know how to review that purchase order, and that is what we're going to talk about now. But the second thing you're going to do, what I thought you were going to say, is a lot of times they just say, well, get out here tomorrow. You send them your proposal, they don't sign it, and they don't send it back to you, but they say, hey, are you coming out here tomorrow or aren't you, right? I think you have a very strong argument, probably a winning argument, that this contract is your contract with this debtor, okay? You send them a detailed proposal, they say, get out here. If it's a uniform commercial code sale of goods, if you're a supplier, there's no question that's the contract. That's the way the battle of the forms works. If you're a labor and materials subcontractor, you're supposed to get a signature, is the only way you can be sure. But even if you don't get a signature on those facts, you send a detailed proposal, they say, get your rear end out here. I'm in court pounding on the table. Well, Judge, they obviously agreed with the terms. They had received this when they told us to come. You will probably win that case. Can't guarantee it. You will probably win it. The third thing you're going to do, and this gets to the counter proposal or the purchase order, is you're going to attach your proposal to any subcontract or purchase order that the debtor sends you. You're going to add this sentence. My proposal of this day is incorporated herein by reference. And you probably want to put it in the scope of work, right where the debtor has listed the scope of work, the plans, the spec, the schedule, whatever he's talking about. You add this one sentence. My proposal of this date is incorporated herein by reference. That's all you need to do, and your 8.5 by 11 page of terms is a part of that contract. It's a part of that purchase order. Now, while we're on the subject, let me flip it back the other way and make sure that you understand. I get a lot of cases that clients bring in their subcontract agreement and they have this problem or that problem, and then they want to tell me, they want to say, but my bid said, or my proposal said, and I'm in the uncomfortable position of telling them, it doesn't matter. Your bid vaporized the moment you sign that subcontract. That is the rule. The purchase order you signed probably says that. It's what you call a merger clause or a precedence clause. This agreement will rule over any prior negotiations or documents or proposals that were sent back and forth. That's a merger clause. Your contract probably says that, but one thing that surprises people sometimes is to learn that that is the rule of law. That's the rule, whether the subcontract says that or not. And if you think about it, it makes sense. It's just like why we have limited liability entities, because it makes sense. As a society, we really want to know when we get to the end of a final agreement. And that has just always been the rule of law in the English tradition. If you're negotiating, whatever you care about, you got to make sure it's in the final agreement. 2 years later, you can't say, well, but wait a minute, 6 months before that, I told them this. That doesn't work. And you don't want it to work because there'd be no certainty, there'd be confusion, there'd be more disputes. So that is the rule of law. You need to incorporate your proposal by reference. That's all it takes is that one sentence. It's even better if you get a stapler and attach it to their purchase order. Similarly, another attachment I gave you is an addendum to contract. This is 2 pages, 8.5 by 11, so it's a little more detailed. But any purchase order you receive, if you could, you'd want to attach this to it. And I have clients that do that, and I swear they say it works sometimes. Because these are all reasonable, fairly even-handed terms that are on here. I will agree with you that you're often not going to have that opportunity if you're dealing with, your typical big commercial general contractor. That's going to be difficult. But both of these documents, you can use them as checklists of the type of provisions that you're missing or the type of provisions you may want in there. And so you may want to just take 1 or 2 paragraphs out of this or this and put it in the purchase order, which is kind of what we're going to talk about now, reviewing those proposals and how to deal with them. Okay, one more point about proposal forms. We decided this might end up being your entire contract. Please make sure you have payment terms on there. You do need to make sure there is a progress payment schedule or a payment terms on there somewhere. And what I'm thinking of is the general rule of law that applies, in the English common law tradition. The money is due when the work is complete. And if you have a contract that calls for 6 or 9 months of performance, they don't have to pay you anything until you're done. And that could take 6 months, 9 months, 12 months, and that's a problem. If you want it to be that you get paid once a month for the work you put in place, you have to make sure your contract says that. So on my proposal form and on your form, one of the things it says on there, one of your choices is to say you'll be paid monthly for work in place, or I get paid 90% of the value of work in place on a monthly basis. That's all you need to say, but you need to at least say that, or the contract debtor has no obligation to pay you until they are complete. Also, while we're on the subject, please be careful with the plans and specs. That's your department, not mine. Make sure that the plans that you bid from, make sure the plans of the same date with the same addenda are described on your final contract. In other words, a very common problem is that you bid one set of plans while the owner and the architect keep revising those plans, and a different set of plans is described on your contract. You must notice that. That's your department, not mine. Okay. Notice an opportunity to cure. This is similar to what we discussed this morning about they got to give you notice of any defect within 10 days. Now you've received this purchase order, and this is what it says. And I'll look for volunteers to tell me what that means. When you receive that written notice, what can you do? Nothing. You're already terminated. You receive no notice until the notice of termination. You no longer have a contract. And that's patently unreasonable. If you talk to your customer about that and say, well, wait a minute, let me get this right. If I do something wrong in this project, you're just going to send me a notice that says I'm terminated. You're not going to tell me that I'm in breach of contract. You're not going to tell me what I need to do to fix it. What will they say? Oh, of course I'm going to do that. I'll give you written notice. I'll want you out there tomorrow. And your response should be, great. Let's just have the contract say that. Makes a dramatic difference. You have redefined the breach. You are not in breach of contract until you have received written notice specifying the breach, and you have failed to diligently begin to cure that breach within 10 days. Now you're in default, not before that. Okay? One of the important features of that we mentioned this morning is that makes it much harder for the debtor when you finally hire me and we sue them and we get into discovery and we're in court and 6 months have gone by and you start getting this list of the 35 things you did wrong on the project. They never gave me written notice of that. It's not going to stick. Okay, that's a huge difference.
What about a termination for convenience?
Well, good point. That's kind of like the indemnification clause. I'd respectfully submit to you that it don't matter. I think you're okay with that. It's a little bit disconcerting that they can just decide to terminate you, but I would submit that nobody's going to do that unless they have to. It's because the project has been terminated or because the owner went bankrupt or something. It really comes from government contracts. It's a required term in government contracts because if Congress decides they have to go fight a war in Iraq instead of building this post office, the government's going to need to do it, and the project's just going to have to wait a couple years. And so the government can always terminate a contract for convenience, and then the GC has to know that if they're terminated, they can terminate you. Where the other place it becomes important is you have a lot of default termination, and this would be an example. Let's say you succeeded in making this change. They have to give you notice and an opportunity to cure. One of the most important things about that is it puts you in a much better position to argue that was a wrongful termination. They sent me a termination notice without giving me written notice of my default, and they did not give me an opportunity to cure. That's a wrongful termination. They cannot back charge you a dime for anything if you were wrongfully terminated. That's a huge difference. And so what comes right after that in a lot of contracts is a termination for convenience clause. It says, if I ever terminate you and a court finds that you were wrongfully terminated, it will be treated as a termination for convenience under this clause. Oh well, that's a problem. But in a termination for convenience, you're entitled to your contract price for all work in place. Yeah. So it's not the end of the world. It's not going to happen unless there's huge problems of some type. So I think it's not worth arguing about. Okay, so this is what your contract says, and this is what you should do, or it's what I do for a living. If seller breaches any provision of this contract, you get your pencil, you put a line up here, and use a ruler because it looks a lot better. You run a straight line out here with a ruler, and then you put a line right down like this with a ruler, and then you write right on that line, and seller does not begin to diligently cure within 10 days after written notice specifying this breach. That's how you modify it. You didn't have to change that many words. You didn't cross out anything on their contract. You've just dramatically changed the definition of default and breach on this contract. A couple of little tidbits. Notice, I don't care so much about the 10 days. What I care about is written notice, for reasons we've talked about several times. It keeps them from claiming other things later that they never told you about. But notice also, your only obligation is to begin to diligently cure within 10 days of receiving written notice. Some things take more than 72 hours to fix. Some things take more than 10 days to fix. As long as you diligently begin to cure within 10 days, you cannot be terminated. You are not in default on this contract. That's what you care about. All right. Waiver of mechanics lien bond rights. I used to just say, find them and cross them out. Until 2 years ago in Virginia, a waiver, I guess I'm getting old, maybe it was 3 years ago, I don't know, 4 years ago. A waiver in a contract in Virginia was enforceable. You just voluntarily agreed to be an unsecured creditor. That's still the situation in DC. If you sign a contract with a waiver provision, you are an unsecured creditor. But in Maryland has had a savings statute for as long as I've practiced law, which has been a while. It's a part of the mechanics lien code and a part of the payment bond code that a waiver in a contract is ineffective. Virginia added that just a couple of years ago. The Maryland one, just while we're on the subject, we don't have a lot of time to get into this, but the Maryland one is interesting because what it goes on to say, a pay if paid clause, even if there is a pay if paid clause in your contract, it does not impact your mechanics lien rights. It does not impact your payment bond rights. And that's very interesting and very helpful. Where you end up is if there's a pay if paid clause in your contract, you could not sue the general contractor because the money is not contractually due to you yet. They're not in breach of contract yet because they haven't been paid yet by the owner, but you can sue the owner and start foreclosure on your mechanics lien rights, which will tend to kind of get you to the same place where you want to be. Now, the Virginia statute, we're going to have to wait to find out what it means. We're waiting for the Supreme Court of Virginia to tell us what it means. And if any of you guys want to, I would be thrilled to take one of your cases all the way to the Supreme Court of Virginia and find out what this statute means. It says any contract provision that diminishes lien rights is unenforceable. So that certainly tells you that a waiver is unenforceable. What's that mean for a pay if paid clause? Does a pay if paid clause diminish your lien rights? Maybe. Or that diminish your right to claims, extra money? How about a written change order provision that says any change has to be in writing? Doesn't that diminish your right to extra money for additional labor and materials?
So are you saying that the pay what paid clause could also be ineffective?
In Virginia. And I'm waiting for the case to find out.
Allowing us to go after the general contractor even if we have that.
Even if they have not been paid. Because that pay if paid clause diminishes your lien and bond rights.
And how long has that been around?
2 years?
Now, you'll take that case pro bono, right?
Oh, yeah, absolutely.
Go on, don't worry, I got a few.
No, I want to assure all of you of one thing. I will defend you to your last dollar. You can be sure of that. All right. The new battleground, I remember the first time I ever saw a pay if paid, I couldn't believe it. I'd never seen anything so outrageous in my life. And of course, we've all gotten used to it. It's in most contracts. You will not be able to change it in most cases. This is kind of the new battleground, but I would really encourage you to fight about this. Buyer, in its sole discretion from time to time, may change the time periods or durations for the sequence of work. Let me translate that for you. What that says is, I'll tell you what the schedule is when I'm good and ready to tell you what the schedule is, and if you don't keep to it, you're in breach of contract. You cannot agree to that. It comes in a lot of different versions. This one's longer, same result, just in even more explicit language. You're liable to the buyer for failure to adhere to their schedule, including amendments, even if they differ materially from the schedules given you. You see this in a lot of contracts. Again, you put your two very important words. One is reasonable, and by mutual agreement. I guess that's 3 words, 4 total. But it's not very many words. It makes a big difference. I like to say, I remember Vic Rinaldi, who hired me out of law school, used to always say, you gotta give the judge a hook to put their hat on, to hang their hat on, right? Judges are gonna enforce the contract the way it's written, but if you just got your ruler and your pen and including, put your line up here, put the line out there, put the line here, and put reasonable. That enables the judge to say, well, yeah, but he's only bound to adhere to reasonable amendments, and I think that's unreasonable. I think it makes, what's reasonable mean? Sure, it's arguable, but I think it makes a big difference. And this is a common question. The rules of contract interpretation dictate that any specifically negotiated term rules over pre-printed form terms. So in other words, you do that with your ruler and you write the word reasonable out there, that's the controlling term. Even if somewhere else in the contract it said no matter how unreasonable those amendments are, the parties obviously negotiated a reasonableness standard up here, and that's what's going to be enforceable. So these handwritten interlineations can be sloppy sometimes, but they're very powerful. The other thing you could do is say, including amendments made by mutual agreement. That's even stronger. Our agreement is necessary, and I think it's reasonable. The schedule is a material part of the contract. That's important to all parties, which is really all this means. That gives me an opportunity to discuss this. A lot of people want to ask about the time is of the essence clause. You're fine with that. All that means, and that's very old phraseology from English law, time is of the essence. All that means is it is a material term. The people signing this contract care about the schedule, right? And that's important. If the contract did not say that, the general rule is performance within a reasonable time. And if it did not say time is of the essence, and you got sort of kind of close to keeping the schedule, that's good enough. That's not really acceptable to most owners and most GCs. If you're supposed to show up on Tuesday, you need to show up on Tuesday. Time is of the essence. That's all that means. So you're generally okay with that. There it is again, just another example of the same thing, reasonable, or as established and as reasonably amended, or as amended by agreement from time to time. You want a definite schedule, you want a definite start date, but we talked about the time as a termination of convenience clause. Another one that comes from government contracts is that you'll proceed on a notice to proceed. We're not telling you when the contract starts. We're going to give you notice to proceed. You probably got to agree to that because, you know, the owner wants to start as soon as the financing's lined up and this and that. You may want to say you need 15 days notice before you have to start or something like that. But what you care about is having a set number of days to perform. After that notice to proceed, I'm going to have no less than 45 days of unimpeded access to the site in which to perform my contract. That's what you care about. All right, force majeure. The most important part of this is in red. That's what you call a force majeure clause, which is also, you know, old common law. That's actually a French term, and also a Latin, I think it's a Latin term, but where a lot of common law comes from. Force majeure, at least in French, means a force that cannot be controlled, an uncontrollable force. And my main point here is that a lot of people think this is the rule. In other words, I tell a client, well, you're in breach of contract. It says it's supposed to be done by October 20th, and it's November 11th now, so you're in breach of contract. They say, well, you know, the site wasn't ready. The weather was bad. An airplane crashed into the construction site. Who cares? You agreed to be done by October 20th. You're not done by October 20th. You are in breach of contract. It doesn't matter why you were not able to finish. If what you mean to say is you're not responsible for delays caused by things out of your control, you have to say so. That's an extremely important sentence, a force majeure clause, to add to any, and you can get people to agree to it. It makes sense. It doesn't take that many words. That's what you're looking for in things you can change in a contract. Interest and attorney's fees. The burden of changing the status quo. I think we mentioned this morning, the burden is on the creditor. The debtor, in all of your contracts, whoever the debtor is, it might be your customer or maybe you're the creditor on this deal. Sometimes you're creditors and sometimes you're debtors. But the debtor has all the leverage in all of your contracts. They have your labor and materials. They have your money. If nothing ever changes, they're fine. You have a leverage problem. You've already shipped the $100,000 in labor and materials. You don't have your money yet. You have a leverage problem. They don't need an attorney's fee provision as much because if they think something's wrong with your work, they're going to send you an email saying, get out here and fix the following 3 things, and I'm not giving you a dime until you do. You're going to be out there the next morning and get it done. They don't need an attorney's fee provision to do that. The attorney's fee provision is much more important to you as a creditor than it is to the debtor, is my point. This is a unilateral attorney's fee provision, just like the one we were looking at this morning. The one we were looking at this morning says, if you, the buyer, breach this contract, you'll have to pay my legal fees. And I told you that's the penalty you can make them pay. This is unilateral also. It only goes one way. If you, the seller of labor and materials, breach the contract, you're responsible for all attorney's fees incurred by the buyer. The reverse is not true. It doesn't matter how much they breached the contract by failing to pay you for 6 months. You cannot make them pay legal fees. That's also indefensible. You can get people to agree to this change. You say, and those are the words you speak. You say, well, let me get this right. if I ship you defective material, you can sue me and I'm gonna have to pay all your legal fees, but you can just spin me around for 6 or 9 months and not pay me, and you'll never have to pay my legal fees. Is that what this says? It's patently unreasonable. They will agree to change it, and that's all you do. You're just striking 4 words and you're adding 3 words. And you've converted this from a unilateral attorney's fee provision to a bilateral. And part of the discussion of the status quo, part of the point is, if you're a creditor, you're always fine with giving them an attorney's fee provision. It doesn't matter. What you care is that it's working towards your benefit, because you're going to have the burden of changing the status quo. Or you can just add a bilateral provision. I have some clients, it's the only thing they understand about contracts, and I'm glad if they got this. And this is right in the book. Somewhere, right above your signature, up the margin, somewhere, you just add this sentence. If either party breaches the contract, the other one's responsible for legal fees. And if you don't do anything else, that's big, very important. Okay, we talked about the right to verify there's funding for the project. This is the AIA, the new AIA contract form provision. And if nothing else, I want to make sure you understand this, that this is in some of the contracts you have. Please make use of it. And it's also, in reviewing contracts, if things are getting really nasty, one thing you can consider saying is, listen, let's just use an AIA subcontract form. You can get people to agree to that a lot of the time. This is one of the reasons you like that. There's also an attorney's fee provision in there. This has your right to verify funding, and where that becomes particularly important is in the case of defects in the plans and specs, scheduled delays, changes in the plans and specs. Those are all things that are going to impact the budget and impact the owner's ability to pay. That's when it becomes critically important to request verification of funding. I'm going to stop there, but the next thing that happens in the book is Chapter 5, conduit clauses, pay if paid, change orders, delays. That's Chapter 5, which is a lot longer than Chapter 2. We could do that for a whole day, changes and claims, and I'd be happy to do that for a whole day, but we'd have to set aside a whole day to do it.